Good morning, Mr. Ramlogan. I don't think he can hear me. Good morning, Mr. Ramlogan. Can you hear me? Can you hear me, Mr. Ramlogan?
I am hearing you now, my lord, loud and clear.
Thank you very much. Well, good morning and good afternoon, Sir James. It's your appeal, Mr. Ramlogan.
Indeed, my lord. My lord, grateful to the board, firstly, for accommodating me via this virtual hearing. I appear for the appellant, leading Miss Jody Blackstock and Mr. Mohammed Jameh Hafiz Beg of the Bar of England and Wales, were instructed by Mr. Ganesh Sarup for the appellant. The respondent, the National Gas Company of Trinidad and Tobago, is represented by Sir James Eady, King's Counsel, and Mr. George Molyneux, both of the Bar of England and Wales. My lord, this case concerns the Freedom of Information Act of Trinidad and Tobago, and that is a revolutionary piece of legislation the world over, but of particular significance to a young democratic nation that gained independence in 1962 from Great Britain. It's a fledgling and maturing and developing democracy, and it has been described as the citizen's torchlight, and something that has revolutionized the concept of participatory democracy and has strengthened the rule of law by giving the public opportunity to participate in political discussion and the governance of the country in a way that was hitherto not possible except for the voting at elections, perhaps. Now, the case centers around a rather unique structure and model that we have in our freedom of information law, in contradistinction, perhaps, in contrast to Britain and other countries where you have a tiered tribunal approach to decisions made by public authorities, where you might have tribunals and appellate tribunals and quasi-judicial bodies. We don't have all of that. Our model is collapsed into one. Your singular opportunity lies with a claim for judicial review, which is given to you by the Freedom of Information Act. And that has enormous implications as to what is the role of the court in light of that, and I'll come to that in due course. We have an override, Section 35, so that the structure of the Act is that even if requested information is deemed to be exempt, that is not the end of the matter, because the public authority is mandated by Section 35 to conduct a balancing exercise to determine whether, notwithstanding the exempt status of the requested information, it should nevertheless be disclosed in the public interest. And we are concerned with that latter limb in Section 35 in this case, which deals with the question of whether it is disclosable in the public interest. In this case, we say that Section 35 is a mandatory step in the prescribed decision-making process. And if it is not complied with in accordance with the law, then the decision is invalid. The access decision is invalid. And we say the normal, natural legal consequence of that is that the decision ought to be quashed and remitted to the public authority for it to reconsider. One striking feature of this case, to which I'll come, is the fact that the access decision contains no reasons. And we say that that is also another ground for invalidating the decision, and that the courts below were wrong to allow ex post facto rationalization of the decision in response to the claim for judicial review, because that's simply not what the law contemplated. Section 21 of our Judicial Review Act codifies the common law remedial discretion in administrative law for the court to remit the matter to a public authority with a directive for it to reconsider the matter and reach a decision in accordance with the findings of the court. If there is no valid access decision in accordance with the Act, well, then there's nothing much further that should happen except we say quash and remit. But even if there may be an exceptional circumstance in an appropriate case where the court can step into the shoes of the decision maker and review the defective, invalid access decision, because that might best meet the justice of the case by direct judicial intervention, we say this is not an appropriate case where that extraordinary step should be taken by the court. We say there are two categories of cases where there was no balancing exercise done, which we say is the case here, where there was no Section 35 balancing exercise done by the public authority. We think it's a simple matter to quash and remit. If the court finds that a balancing exercise was done under Section 35, and the court can review that, and we say in that circumstance, it will review it on the basis of traditional principles of judicial review: rationality, proportionality, and fairness. We say, however you cut it, twist it, or dissect it, NGC, which is the acronym for National Gas Company, the respondent, simply reached the wrong result, and the decision ought to be quashed. NGC is an independent company that is owned by the government, but it is run by its own independent board of directors, who obviously will owe their fiduciary duties and responsibilities independent of the shareholder, and must act in the best interest of NGC as a commercial entity. And that's an important point, because we cannot equate or conflate NGC with the government. It is an independent company. Its shareholder is the government, but it is run by an independent board of directors whose duties are owed to the company itself. My lords?
Mr. Ramlogan, can I just check one thing with you? I think
Yes.
it's implicit, or indeed perhaps even expressed in the submissions you've made so far, that you say that the relevant test to be applied by the court is a judicial review approach regarding the decision-making by the relevant body that holds the document. Do I take it from that you regard the majority in the Court of Appeal, insofar as they said that this was a decision for the court for itself rather than on a judicial review basis, insofar as they said that you would not support that as the relevant approach?
My lord, no, I wouldn't go so far. What I say is that the court erred in finding that a Section 35 analysis or balancing exercise was done. We say that it was clear, it's clear in the evidence, it was not in fact done. And if it was done, it was deficient and not in compliance with Section 35. And in circumstances where no Section 35 analysis was done, the decision is invalid and ought to be quashed and remitted. In exception, so far as if a Section 35 analysis was done, and you have the benefit of the reasoned decision from the public authority, including the Section 35 balancing exercise, the court can review that. The standard of review, there are two options. The courts in Trinidad have adopted either what's called, Melinfred said, the correctness approach, or alternatively, the normal judicial review approach. I say firstly, my lord, if the court is going to review it, given that we don't have any intermediate body such as exists in other countries where you have an information commissioner or tribunal to appeal to in the first instance, I say the court can adopt the correctness approach to say applying Section 35, did they arrive at the correct result? In the alternative,
I'm sorry, I didn't hear that answer.
Yes. Am I right? Were you saying that your submission is that the court should adopt the correctness approach rather than the judicial review approach?
I say in the first instance, yes. The court can review the decision to decide on the correctness of the decision by reference to the legal principles in the Act. I say in the alternative, if the board is not with us on that, in the alternative, it will then fall to be decided by ordinary judicial review principles, i.e. rationality, proportionality, and fairness.
When you say that the court can adopt a correctness approach, is there anything in the Act other than the fact that there aren't specialist tribunals involved in this process to support that assertion? Because Section 39 simply says a person aggrieved by a decision of a public authority may apply to the High Court for judicial review. There is no indication that there is a special rule relating to freedom of information.
Well, my Lord, I appreciate that. And my Lord, this is a discussion, you may recall, my Lord Sales and my Lord, my learned President, Lord Hodge, would have been members of the panel in the Petrotrin case, Devant Maharaj. And there was some discussion about what should be the correct approach. Now, there has crystallized a considerable body of consistent jurisprudence in Trinidad from the Court of Appeal that they will adopt the correctness approach. Now, my Lord, I say out of deference to that body of jurisprudence, I feel compelled to say that, look, that is an option that is open to the court. Having said that, my Lord, I see, of course, I see the force in saying that could infringe on the cardinal principle of judicial review, that you don't usurp the role and function of the decision maker and substitute the discretion of the court for that of the decision-making body itself. What you ought to do is to remit, or alternatively, you can judicially review on the traditional grounds of judicial review. So, my Lord, I won't press it beyond that, but I can't say that I can safely abandon as a first port of call that they review it on its merits, as it were, on the correctness basis. So I will say that I support the approach taken by Justice of Appeal Jamada in the Joint Consultative Council case, and also Justice of Appeal Barrow. But I say in the alternative, even if we were to find that that is not correct for the reason I've outlined in terms of breaching those cardinal principles, even on the traditional judicial review principles, in this case, if that were to be an exceptional case that is appropriate for judicial intervention beyond quashing and remitting, then of course we say that the respondent fails even on that.
Well, just before we leave what may be quite an important legal point, could I draw your attention also to section 22.2 of the Act, of page 1074. So section 22 provides
yes.
A decision in respect of a request may be made, and then it identifies a series of persons who may make the decision,
yes,
which is not a court. And then 22.2 says, where a request is made to a public authority for a document and no arrangements in respect of documents of that type have been made and published under the regulations, a decision on that request shall, for the purpose of enabling an application for judicial review to be made, be deemed to have been made by the responsible minister of the public authority. So again,
yes.
in line with section 39, it might be said that that's an indication that it's not a correctness approach, it's a judicial review approach, and the relevant public authority who is to be judicially reviewed is specifically identified under the legislation. I just wondered if you wanted to say anything about that.
Yeah, my Lord, the way I view that is a default provision. It really means that the minister is to be sued eo nomine for the purposes of having a respondent to facilitate the application for judicial review. But in Section 7 of the Act, there's an elaborate machinery set up in the Act, which where public authorities are meant to publish their annual statements. They must have a designated officer, and all public authorities comply with that, so that it will be a very rare and exceptional circumstance where the public authority, as a self-contained, compartmentalized public authority in its own, independent of the government, doesn't have a designated officer under the Freedom of Information Act as required by the Act, so that you will have to use the default position to sue the minister. So that I don't attach to myself any great significance to the point that you can have a fallback position in the event there is no designated officer who is designated as the FOIA officer for a public authority, such that means there's a legal implication to be derived from that it is conducive to judicial review on traditional principles.
Is it right you didn't challenge the decision on correctness grounds in the courts below?
Well, my lord, our case in the courts below was that the process and the procedure in the Act to arrive at a valid access decision simply wasn't complied with in this case, in consequence of which we should quash and remit. And we say that for two main primary reasons. One is the Section 23, which required a reasoned decision for reasons to be contemporaneously given in the access decision letter. That was not complied with. And we say that is of huge importance and significance, because that ties in directly with your right to judicial review. So that's the first error. And the second error is, of course, that of this breach of Section 35, where there was no balancing exercise, or if there was one, it was not in compliance with Section 35, in consequence of which, again, there was no valid access decision. So that our case is it's a null. The decision is a nullity because it's invalid, and therefore the court should quash and remit, because this is not a case where it would be appropriate for the court to undertake the balancing exercise itself. So, my lord, strictly speaking, the question of the appropriate test an approach to be adopted by the courts, whether it's correctness or rationality on traditional judicial review grounds, ought not to arise in this case, we say. That is a matter that might be appropriate for another case where the public authority did undertake a proper Section 35 analysis, but it is being challenged, and the court is seized of all of the facts that the public authority would have considered, has a reasoned decision in accordance with the Act, and the court can then undertake a proper review of the public authority's consideration and reasoning to arrive at that decision. But we say that is not the case here. And in any event, given the political hypersensitive issues involved in this matter, it cuts too close to almost the separation of powers for the court to consider a matter that is so pregnant with political implications that are best left to be decided by the executive and not the court, at least in the first instance, where no Section 35 analysis was done.
Mr. Ramlogan, again, still on this question of whether it's the correctness approach or a judicial review approach, which is the appropriate test to be applied, could I ask you about Section 38A of the Act, which is at page 1088 in the bundle? And this is the provision that provides that a person aggrieved by the refusal of a public authority to grant access to a document may complain to the Ombudsman, and the Ombudsman may make recommendations. You see that?
Yes.
And then if one goes over the page to Section 38A3, what happens with recommendations under subsection 3 is that a public authority is required to consider the recommendations of the Ombudsman, and to such extent as it thinks fit, exercise its discretion in giving effect to the recommendations. Again, it might be said that that itself is an indication that the way this legislation works is by the public authority exercising a discretion subject, of course, to all the usual public law constraints on the exercise of a discretion, giving rise to a judicial review application if they be breached, rather than a correctness approach. And again, I just wondered if you wanted to say anything about that.
Yeah. My Lord, I see the point in that. One can see that perhaps the role of the ombudsman might be more conducive to a correctness approach, arguably. The truth of the matter is, my Lord, this provision, although it exists, it's hardly ever used because the delays that attend on freedom of information applications in Trinidad and Tobago is nothing short of a disgrace. Because this case is very typical, quite frankly. We are almost a decade later and we are nowhere in sight to the end. So what happens more often than not is that the delay that is occasioned by the response or lack thereof is such that by the time you go to the ombudsman, the delay is tripled. And of course, the Court of Appeal has ruled that it's not an effective alternative remedy because the public authority is not bound to act in accordance with any recommendation the ombudsman makes. So what has happened in the early stages of this legislation is that to the extent that people exercise the right to refer to the ombudsman, it was stuck there for a number of years. And eventually when the ombudsman did make recommendations after you filed for judicial review against the ombudsman for inaction, then the public authority then gave a decision on the recommendation saying they didn't accept it. And then you had to file a further round of judicial review against that access decision. So in short, the ombudsman is not an effective alternative remedy. It has not been used, so that there is not much I can say about it. My lords, we have to take a practical approach to the administration of the legislation, or else what will happen, what is happening on the ground, is that the object of the legislation is going to be frustrated by delay tactics, hiring expensive lawyers to advise public authorities, and to the detriment of the citizens who are meant to be empowered, consistent with the concept of a participatory democracy. Instead, they're being disempowered.
Yes, Mr. Ramnugger, I may be able to help you to this extent. I wasn't seeking to suggest that Section 38A was an effective alternative remedy. The reason for drawing your attention to Section 38A3 was to invite your submissions on whether that is a further indication that the nature of decision-making to be carried on under this Act is focused on the decision of the public authority subject to judicial review, rather than decision-making by a court on the according to the correctness approach as you've outlined it. That's why I drew your attention to that provision.
I'm obliged, my lord. I'm deeply obliged. So, my lords, in short, we say that the question of whether there was compliance with Section 35 is a question of mixed law and fact, but more law, because there must be some objective fulfillment of the requirements of Section 35 for there to be a proper balancing exercise as envisaged by Parliament when they enacted Section 35. And to the extent that that is a legal question, we say that in this case, the evidence simply doesn't pass muster. My lord, I will come back to the correctness versus the traditional judicial review grounds when I come to that part of my submissions, but I'm grateful to the court for giving me an early heads up that that is a matter of concern to the board. Now, my lords, if the Dragon Gas field is a hydrocarbon natural gas reserve that is located offshore in Venezuelan waters, very close to the maritime boundary of Trinidad and Tobago, with Trinidad and Tobago. And the plan has been for NGC and international partner Shell to work with Venezuela to produce and export this gas. The arrangement would have seen gas being piped directly from the Dragon gas field to Trinidad, where it could be processed through existing infrastructure, converted to LNG, and then exported. Under the proposed arrangement, NGC and Shell would work with the Venezuelan government through the state-owned PDVSA to produce gas from the Dragon field and transport it via a subsea pipeline of some 17 to 22 kilometers to Trinidad's processing infrastructure by linking it to the Hibiscus platform off the northwest coast of Trinidad for liquefaction and export. In short, it's to monetize the gas. Now, the current status of the project, and I think we can take judicial notice of that, is that the US government had granted a waiver in January of 2023. Washington had issued a 2-year waiver permitting limited Dragon operations, but barred direct cash payments to Venezuelan entities. That has since been revoked in 2025, so that the US government had revoked 2 licenses, 2 OFLAC licenses for Trinidad Venezuela projects, including Dragon gas, directing companies to wind down. And of course, that means that the project is now, in jeopardy unless a new waiver can be negotiated. And of course, no doubt steps can be taken and will be taken, but until something concrete happens, that's the current status of the matter. Can I take the board through the Act? Because I think it's important to understand the structure of the Act. I start by taking you to page 1054. It starts at page 1050, and I'd like to go to page 1054 to section 3. It says that the object of the Act is to extend the right of members of the public to access to information in possession of public authorities. I pause to note that it says to extend the right of members of the public. So it is premised on an existing legal right to access information, which Justice Olupi Jamada has given us some exposition in his judgments on about the constitutional right to freedom of information, freedom of the press, and freedom of political expression, and how important this right to access information is context of those constitutional rights. And it says to access information, and B says by creating a general right of access to information in documentary form in the possession of public authorities, limited only by exceptions and exemptions necessary for the protection of essential public interests and the private and business affairs of persons in respect of whom information is collected and held by public authorities. So the use of the word essential public interest, essential qualifies it, so that the limitation and restrictions must be for the protection of essential public interests. I take you next to section 11, which is on page 1066. And section 11 deals with the right of access. It says, notwithstanding any law to the contrary, and subject to the provisions of this Act, it shall be the right of every person to obtain access to an official document, and nothing in this Act shall prevent a public authority from giving access to documents, amending documents, other than as required by this Act, where it has the discretion to do so, or where it is required to do so by any written law or order of the court. I go next to section 15 on page 1068. At the top of that page, can I go to, section 14 first, which is on 1067, beg your pardon. In section 14, we're told a public authority shall take reasonable steps to assist any person who wishes to make a request or who has made a request but does not comply with the requirements of section 13 to make a request in a manner that complies with that section. This is called the duty to assist provision. I like this because this Act is meant to be used by laypersons unassisted with the benefit of legal advice, without making any representations. It is for the people who we say are by the corn soup vendors, doubles vendors, and the bars and rum shops. It's an ordinary man. And the bias in this act towards disclosure is also, it favors the applicant to the point where there's a duty to assist. I make this point because when I come lower down, I'll show you that there is very little onus that Parliament placed on the applicant. For example, the applicant does not have to make representations as to what would be the public interest considerations that favor disclosure under Section 35. And I'll come to that in due course. But that's Section 14. I go to Section 15 on the next page. And at the top, just above Section 15, you will see subsection 3 says, without prejudice to Section 21, a public authority shall take reasonable steps to assist any person in the exercise of any other right under this Act. Section 15. The decision, this is the access decision. The public authority must take reasonable steps to enable an applicant to be notified of the approval or refusal of his request as soon as practicable, but in any case not later than 30 days after the day on which the request is made. So it's as soon as practicable, but the outer limit is 30 days. Section 16, subsection 2 says, where a decision is made not to grant a request for access to a document on the ground that it is exempt, it is practicable for the public authority to grant access to a copy of the document with such deletions as to make the copy not an exempt document. And it appears from the request or the applicant subsequently indicates that the applicant would wish to have access to such a copy. The public authority shall give access to such a copy of the document. Now, one of the points we've made repeatedly in this matter is that you could give a redacted copy of the document to redact sensitive commercial information pertaining to the gas price. And that's a red herring in this case. I'll ask you to bear in mind because we've never asked for the gas price. And if that is the commercial sensitive concern, well, then you can redact information pertaining to the gas price. We go next to section 23 on page 1074. At page 1074, section 23 says, where in relation to a request for access to a document of a public authority, a decision is made that the applicant is not entitled to access to the document in accordance with the request, or that provision be deferred, the public authority shall cause the applicant to be given notice in writing of the decision, and the notice shall state the findings on any material question of fact, referring to the material on which those findings were based, and the reasons for the decision. Now, this envisages a contemporaneous written notice being given with the reasons being simultaneously provided to the applicant. That is what the Act requires. Not that you will separate it, not that it will come in affidavit after you file for judicial review, nothing of the sort. And of course, those reasons, as a matter of public law, must be intelligible, they must be easy to comprehend, and it must be expressed free from ambiguity, but in plain and clear language, so that the average man can understand the decision and the reasons for it. It must not require a convoluted process of intellectual deductive reasoning, so that one has to undergo a process of minute analysis to be able to deduce what the reasons are. And this case falls in that category because what the respondent is seeking to do is to put together a patchwork, a jigsaw puzzle by connecting dots and say, well, look, aha, they had it all. Here's the picture. That's not what the law requires, I'm afraid.
So you don't dispute, do you, that the exemptions have been properly invoked and that proper reasons have been given in relation to those specific exemptions?
No, we don't rest the case on the exemptions. We say that insofar as the reasons were given, they were specific and related to the exemptions. Our complaint is that having decided that the document was exempt, you were mandated by the Act to perform the Section 35 override balancing exercise, and there was simply no analysis as required by Section 35 to determine whether the exempt document should nevertheless be disclosed in the public interest.
Why shouldn't, sorry, Mr. Ramlogan, why shouldn't a person be able to read across from the exemption the reasons relating to exemptions to the reasons?
Sorry, my lord, I'm sorry, you're breaking up, sorry.
I was just inquiring as to why a person, an applicant for information, should not be able to read across from the reasons in relation to exemption to exactly the same reasons in relation to the Section 35 balance.
Well, my lord, for several reasons. The first point is it would render nugatory Section 35 as an override, because the way the Act is structured is that Section 35 is predicated on a finding by the public authority that the document is exempt. So it's a tiered approach. When the public authority arrives on the doorstep of exemption and says, well, look, I think that this document is exempt, that is precisely what triggers Section 35 and the duty to perform the override, the balancing exercise. And if it were that Parliament intended that you can simply copy and paste, as it were, it renders inoperable and nugatory and meaningless the Section 35 balancing exercise, which I say is much wider in its construction and embrace as to what it should consider in the public interest. When you look at the exemptions, whatever is considered, and the axis of it is located in the exemption itself. It's relative to the exemption. But the wider public interest considerations that the public authority is mandated to take into account under Section 35 cannot be shoehorned or subsumed or substituted for the considerations that would apply when they decide whether it's exempt or not, my lord. That is, and I'll come to Section 35 to show you the wording, and that's why I'm going through the Act chronologically. So we'll see how it is structured. So we get to the reasons, and the other point I want to make on the importance of Section 23 and the reasons is that the reasons here allow you to determine whether the Section 35 balancing exercise was performed and whether it was adequately and properly performed. The reasons are directly linked to the Section 35 and the exemption. It's both. And we are given a clue by Parliament, apart from the inherent bias towards disclosure in the Act, when they tell us in 23(1)(a), they go so far as to say, state the findings on any material question of fact, referring to the material on which those findings were based, and the reasons for the decision, which applies to the entire decision. But the point is, it's not meant to be a mere recitation or mere assertion of this section, but rather a more deeply analytical, reasoned decision that is given by the public authority. And why is this so important? It is important because the right to judicial review is obviously linked to this decision, this access decision letter. The reasons you are given in the access decision letter is what you will then use to assess whether to file a claim for judicial review or not. You will take the access decision, you will read it, and you will think about it. You may want to seek legal advice if you can afford it, but you will then decide, well, look, if these are the reasons, I'll take this, I'll file for judicial review or not. But how fair would it be? And Parliament must be presumed to have legislated with fairness in mind. How fair would it be to say that a public authority can give you a vague and obscure decision letter in terms of the reasoning, or give you one set of reasons in the decision letter, and then when you file the claim for judicial review, they file a 114-page affidavit detailing with great comprehensiveness what the reasons are for the decision ex post facto. That's simply not how the law was meant and intended to operate. It turns it on its head and it frustrates the objective and purpose of the act. And that is our complaint here. Our complaint is that, and this is a complaint, my lord, you will not believe, my lord, the amount of litigation that this act has generated, because public authorities are well-resourced, well-funded, they get the best legal advice money can buy, and what you have is shadowboxing to delay and frustrate. So that, if you give people one set of reasons and you hold to your chest your trump card, and you can deploy that with impunity if they so decide to file a claim for judicial review and say, aha, I've caught you out now behind your back. Well, I mean, that's cat and mouse. That kind of cat and mouse game is not what the act intended for lay people to be outmaneuvered and outfoxed by virtue of hardcore litigation tactic and strategy. And that's precisely what has been happening. And it is generating a lot of unnecessary litigation. This case is but a mere illustration of that. So I move on from section 23 and I take you to the exemption provisions. Part 4, which is on page 1075, deals with the exemptions. I don't plan to spend time on them because we are not, as my Lord Hamblin quite rightly noted, we are not challenging the invocation of the exemption. Can I take you, in the interest of time, to section 35, which is at the crux of the case? That's at 1087.
Well, just before you do that, and I think this is to return to a point that Lord Stevens was putting to you. If one looks at the particular exemption provisions, one gets an indication from the exemptions themselves as to the nature of the public interest which lies behind the decision to include an exemption in the Act. So, for example, if you look at section 26 on page 1077, International Relations Documents, it's an exempt document if disclosure would be contrary to the public interest and would prejudice relations between the government of the Republic of Trinidad and Tobago and government of any other state. So one gets from the face of the various exemptions a statement of the public interest which is sufficiently affected as to give rise to a statutory exemption in the first place. Is that not right?
Yeah, my lord, that is correct. But my lord, that's why my submission on that, my lord, is that has got to be viewed in the narrow context of the exemption. And the section 35 contemplates a much wider angle and a different lens altogether on the matter. And my lord,
the provisions of some of these exemptions themselves incorporate reference to the public interest.
It does.
For example, 26A, 26C, 33(1)E, which suggests that the consideration of the public interest and consideration of qualifying as an exemption are not necessarily watertight compartments.
Well, my lord, I will be the first to say that some of the considerations that would apply when looking at that in this ingredient in the exemption, because it's not in all of them, but it's in some of them, and I would be the first to say that that would be something that you can that would be relevant to the balancing exercise in section 35, so that yes, you can reference that and rely upon it in the balancing exercise in section 35. But what I do say is that it is not a substitute for section 35, or else it renders section 35 completely nugatory and meaningless.
I don't think it is being suggested that it is Mr. Ramlogan, is not being suggested that it is a substitute, but at present I cannot see the reason why it is necessary for a public authority to write out again all the same public interests that favour non-disclosure that have already been set out when they've been considering the exemption provisions. Well, why is it necessary to, as a matter of form, to repeat it all at the Section 35 stage? That is the public interests that have been already referred to in the exemption exercise. Why is that necessary?
Well, my lord, I don't say that it's necessary to repeat it. I readily appreciate that it is something you will put on the scale in conducting the balancing exercise in section 35. So you can say, well, for the reasons given above,
Why do you have to even why do you have to even put in the words for the reasons considered above? That would descend to using a magic formula, as it were. You read the document as a whole, there are the reasons. Why do you have to add in the words for the reasons given above?
Well, my lord, perhaps you needn't do that. What I'm saying is that those reasons will be, I'm accepting that those reasons will be relevant to the balancing exercise under section 35. What I am saying, however, is that it would not be a complete overlap. Having found that the document to be exempt, the Act requires you to then conduct the section 35 analysis, which requires identifying and balancing all of the public interest considerations, including those underlying the exemptions.
And then just, why can't one read the letter of request in December and the letter of reply in February together? The essential public interest here in favor of disclosure is transparency and accountability. That's the essential core of it.
Sure.
The applicant here set out those reasons, put some flesh on the bones of those reasons. Well, why is it that one suggests that those reasons weren't taken into account by the public authority when it made its decision under Section 35?
Well, not for two reasons. One is, as I'll come to show you, there is no duty under the Act on an applicant to put forward public interest
I entirely accept that. I entirely accept that. So in circumstances where, as here, the applicant has set out reasons of transparency and accountability, why is it that one says, well, they weren't taken into account?
Well, my lord, the first thing is, nowhere in the decision letter does it say that they took it into account. So, and as a matter of evidence, it's simply not there. And one can't make that assumption because in the balancing exercise, you would have had to address it in a more fulsome and a more wholesome manner to say first and foremost, well, which of those did you consider to be relevant? Which did you consider to be irrelevant, perhaps? And in the ones that you deemed to be relevant, how did you treat with it, and what weight did you give to it, and against the competing consideration that militated against disclosure? But more than that,
Mr. Ramlogan, in the decision letter, none of the reasons which are put forward in the request letter are said to be irrelevant. Isn't the inference that they're all being treated as relevant, but they're being treated as outweighed by the particular matters which are then set out by reference to the exemptions in the decision letter itself?
Well, my lord, I think that's an unfair assumption, an inference to be drawn, because it for several reasons. One is we shouldn't have to speculate because the decision letter should have said so, if that is what it did. Secondly, it presupposes and assumes that the public authority did in fact consider all the points raised by the applicant to be relevant considerations and took it into account when it hasn't itself said that. But more importantly, below, the more fundamental point is this. The statutory duty to conduct that balancing exercise and to take into account factors that favor and militate against disclosure is an objective statutory duty imposed on the public authority. It is meant to do it of its own motion. It's not dependent upon an input from the applicant. In other words, the public authority, when it conducts that balancing exercise, it may come up with and take into account other considerations that favor disclosure.
Well, if the applicant doesn't indicate his or her concerns, are you saying the public authority has to try to guess what those concerns are, apart from a high-level issue of accountability and public disclosure. In this case, the applicant has given 4 reasons. The use of public funds, wanting proper management and accountability of what he suggests is $1 billion Trinidadian dollars. Secondly, environmental impact. The public haven't been consulted or advised about it. Thirdly, the involvement of Venezuela with its human rights abuses and the impact of US sanctions, concerns about Trinidad and Tobago's human rights obligations, and fourthly, whether any agreement would be binding without the approval of the Venezuelan National Assembly. So the applicant has considered and stated quite clearly what are his concerns that need to be addressed in terms of public disclosure and accountability. Are you saying that a reasons letter must repeat all these, saying on the one side there are these concerns which you've articulated, on the other hand there are the exemptions, and the balance favours the exemptions? Is that?
Yes, my lord, I do say that. I say that there must in the decision letter there must at least be some analysis to tell the applicant, well, we have considered what you've said, but this is the competing consideration, and this is the fulcrum of the balancing exercise is we've considered it, but we've come to this conclusion, and that's the position. But to write the letter without any form of an analysis of those competing considerations, it just won't be right. I mean, it's unfair to the layperson to say that you must deduce from a decision letter of this kind, because we must test this against every permutation. And it will be unfair for the layperson to say to the layman that you must now deduce from that letter that your representations were all found to be relevant, taken into account, and these, but the factors that militated against disclosure outweighed them. More importantly, you might find a layperson who might not, in fact, have made any representations. And that brings me. That's why I make the point.
You've made that point now, I think, 3 times. But on the facts of this case, your client did make representations about the public interest, very full representations. So I can quite see that if no representations at all about the public interest have been made, there may be some onus on the public authority to do that work, if you like, for itself. But where the factors in favour of transparency and disclosure have been put very forcefully by the requester seeking the documents, why does the public authority have to do more than accept that there is material pointing in favour of disclosure, but then consider that as weighed against other factors which are identified pointing against disclosure? And you say that it's not been indicated that that's been done, but the text in the decision letter, I'm looking at page, I think it's 443, item 1, for example, having set out the public interest factors against disclosure, it said that the documents are not disclosable, notwithstanding section 35 of the FOIA. So it might be said that clearly the public authority has had the balance under section 35 in mind. It clearly has had in mind the representations made by your client about the public interest factors in favour of disclosure, not least because it's replying to that request. And it has set out itself the public interest factors against disclosure. And having weighed those under section 35, concludes that there should not be disclosure. Why can't one get that from a fair reading, both of the request letter and the decision letter?
Well, my lord, I don't think, with respect, that is what the Act intended. And that jump, my lord, there are a couple of hurdles involved in making that leap of logic, which I've alluded to. I mean, it presupposes, it's predicated on the assumption that the public authority, A, found all the representations that the applicant put forward as being relevant, 2, that it took them into consideration, and 3, that it, in weighing it up in the balancing exercise, it came to this decision without the public authority actually saying so. Who knows whether or not they took some into account but ignored others because they didn't deem them to be relevant. But more than that, my lord, it's not enough for the public authority to say that, well, to say what they might have thought of them, or we must assume they thought of them. They're required to give reasons under Section 23. The decision letter doesn't give a single public interest consideration in favor of disclosure. They needed to indicate all the considerations and then balance them. The issue is the reasoning. The public authority must explain, 1, what factors it considered, 2, how it balanced those factors, and why they were outweighed. And this is not a mere weighing exercise, it's a judgment.
Just on that point, by the time that you've identified factors on the one side in favour of disclosure and factors on the other side against disclosure, I'm not sure there's very much more that you can say other than that, in my opinion, the factors on one side or the other outweigh the others. It's not as though these are matters of mathematical precision or indeed considerations of the same character.
No, we're not dealing with commensurable considerations.
Yeah, they're incommensurable considerations which, at the end of the day, a judgment just has to be made one way or the other, where the balance comes down. Is that not a fair description of the mental process that has to be gone through?
I think it is, my lord, but there must be some fulcrum beneath the balancing exercise, so that there must be some reasoning and some level of analysis. Or else what you can, or else what you'll end up with is two tables and a one-liner saying, notwithstanding Section 35, I deny access. You must have some element of analysis, discussion, or reasoning to give to the applicant, so that he will have a better idea, as opposed to a mere recitation of the competing considerations. Mere recitation is not, in my respect for submission, what is contemplated by the Act. And I think that's what's happened in this case. I'm not saying you have to write a judgment, but I'm saying that you must at least have something more than just mere recitation. I mean, you can say, for example, X is an important public interest consideration favoring disclosure in this case, but it is of limited weight because of ABC. But you must engage with the public. You must show some level of engagement with the.
Mr. Ramlogan, in the decision letter, the reasons that your client has put forward in favour of disclosure are not contested at all. So it's not said these are irrelevant or lacking in force. It's just that they've been outweighed by competing considerations of the public interest weighing against disclosure.
Well, I mean, that's one way. That's one way to look at it, because the other way to look at it would be to say that it doesn't anywhere in the evidence, and it should have been easy to see. Well, we have taken your consideration. We've taken into consideration all of the points that you've raised, which favor disclosure. And that line is missing, and for the board to supply it as a matter of evidence, I say it's simply wrong with respect. Why are we drawing an adverse inference, as it were, against the appellant in this matter, when the public authority has not said, as a matter of evidence, that look, we found your points to be all relevant considerations. We've taken them into account. However, because of the following competing considerations, we feel that they are outweighed by these competing considerations, and therefore we deny access.
Mr. Ramlogan, may I just ask you this? I'm not quite sure why you say that an adverse inference is being drawn against your client, just on the basis of the decision letter. The decision letter I would think, is clearly responsive to your client's request letter. As I say, it doesn't contest any of the points that your client makes. They're taken as read. The decision letter sets out public interest factors weighing against disclosure. And in the relevant text, page 443 and in the other places, where it gives the conclusion the documents are not disclosable notwithstanding section 35, one might think that that is a clear indication that the decision maker has very specifically turned their attention to section 35 because they say so in express terms.
I accept that the letter is a reply. Whether it's responsive to those considerations, it's a different question. I mean, it's a letter that comes sequentially and chronologically after, so that it's a reply to that letter. But whether it's responsive to that, it's a different question. It's an altogether different question. And the fact that the letter comes chronologically as a reply to a letter that precedes it is not, in my respectful submission, the same as saying that it is responsive to those considerations that were outlined in that letter, and that it was taken into account. The submission here is that if the public authority did not see what I said earlier, which is that we have taken note of your representations as to what the public interest factors that favor disclosure are. We have found them to be relevant considerations. We've taken them into account. However, we found the following listed competing considerations outweighed them, in consequence of which the decision is to deny access. Well, then perhaps I wouldn't be here. But where it is silent and doesn't say that, then the principle of evidence is that the adverse inference should be drawn against the public authority that didn't say that, instead of supplying the omission and seeking to cure it by saying, well, I mean, it's a letter in response, so they might have done it, or they should have done it, or maybe they did do it, but we don't know. But you must assume that they did it.
Mr. Ramlogan, could you help me in relation to one matter, and that is section 31, subsection 4 of the Act, which you find at page 1083. This categorizes a document as exempt if it contains information of a business, commercial, or financial nature, and would, if disclosed, be likely to expose the public authority to disadvantage. Okay?
Yes.
Is there any weighing of different public considerations there? If it falls within that category, is it an exempt document? Is there any? It does, yeah. If you could then turn to page 442.
Yes.
Which is the response to of the public authority. And at the bottom of the page, on the right-hand column, you will see that they declined to disclose the information because it's information as identified in section 31(4), which would expose the gas company to disadvantage. And then it goes on in the last sentence, at this time, public interest considerations in favor of disclosure do not outweigh considerations of competitive disadvantage. So it wasn't necessary. If you're looking to see whether or not that is an exempt document, it isn't necessary for them to say that we've taken into account the public interests in relation to disclosure. And therefore, on a fair reading, wouldn't that just be a reference to the section 35 balance? Because it's only at that stage that you take into account the public interest in favor of disclosure. And the public interests that are being referred to there, presumably, are all the public interests which are referred to in the request letter of December.
one doesn't know. One simply, we don't know. And that's part of the problem. My lord,
But we don't know what now, sorry.
but we don't know what are the public interest. We don't know for a fact that the public interest considerations
Can
which the public authority took into account.
Can I break it down? First of all,
Sure.
am I correct in my understanding that in order to be exempt under Section 31(4), the deciding authority, the public authority, doesn't have to take into account the public interest considerations in favour of disclosure? Is my reading of that correct?
I think so, my lord, yes.
And then, at this time, public interest considerations in favour of disclosure, would those encompass, you say there is equivocation or ambiguity about whether those encompass all the public interest considerations that my Lord Hodge identified in the request letter?
Can I pause just to draw your attention to 31(2)(d), which is part of the same exemption clause.
So, section, sorry?
31 subsection 2(d) as in dog.
Yes.
You see, because it says whether there are any considerations in the public interest in favor of disclosure which outweigh considerations of competitive disadvantage to the undertaking.
Okay.
You see,
Yes.
for instance, and it gives an example, for instance, the public interest in evaluating prospects of regulation by a public authority of corporate practices or environmental control. So that's why I made the submission that, you see, the public interest considerations are much narrower because they are they're contextual, and the context is specific to the exemption. And that's why I think Parliament went on to have the override provision in Section 35, because Section 35 speaks to exempt documents. So you first have to determine the document is exempt, and then Section 35 is nevertheless triggered. So that I accept readily that an ingredient in some of the exemptions is a consideration of the public interest from a particular perspective, from the perspective of the exemption. I accept that. However, once the public authority is so satisfied that it's exempt, that the exemption is made out, they nevertheless must then go to Section 35, and they're mandated by Parliament to undertake the balancing exercise. I mean, the commercial competitive disadvantage could, for example, be outweighed under Section 35 by matters pertaining to, the humanitarian crisis and the human rights track record of a particular government or company, matters pertaining to the political instability and the relationship and the impact it will have on diplomatic relations with other countries. I mean, all sorts of things can come into play under Section 35. I mean, the applicant has given some, but they're certain by no means would the list be exhaustive. It will be for the public authority to conduct that balancing exercise to determine whether the exempt information should be disclosed, should nevertheless be disclosed under Section 35. And our case is...
Logan, correct me if I'm wrong, your client has never suggested there are any other public interest considerations in favour of disclosure than those set out in his very full request letter.
No, we haven't, but it's not inconceivable that there might be others, my lord. I mean, for example, one of the points in this matter is, for example, I mean, a responsible public authority may, for example, in light of the concerns raised by the public and the applicant, they may, for example, have engaged with the Ministry of Foreign Affairs and sought representations from them as to what their view is on the matter in terms of some of the issues raised. What's the government position on the issue of impact on diplomatic relations? It could write relevant stakeholders and seek representations from them before it arrives at an informed decision. But it's not to say that we have provided an exhaustive list. What if this was a lay applicant unassisted legally who didn't put forward any representations? Then what?
Could I just take you back to your point on section 31(2)(d)?
Yes.
Surely what that indicates, and indeed what section 31(2)(a), b and c indicate as well, is that
Yes.
if you're looking at that exemption, there's going to be a considerable area of overlap between the applicability of the exemption and the final balance that is likely to be performed under section 35. Because if one sees the way in which the balance is discussed in section 31(2) itself, the conclusion that you come to on that is almost going to answer the section 35 question as well, or come very close to doing so. So I'm not sure that your point on section 31(2)(d) assists you in your submission, does it?
But my lord, I like the use of the word almost, because almost is an important word, because the fact of the matter is almost leaves room for the section 35 balancing exercise to be conducted and to embrace wider considerations than just the mere commercial competitive advantage and disadvantage. And that's the short point. The point is it almost might, yes, in an appropriate case, but the answer is you've got to go forward after you've deemed it to be exempt to conduct a balancing exercise. And one cannot simply speculate or say what the conclusion of the public authority would or should be had they conducted a proper balancing exercise under section 35. But our case is that in this case here, there was no section 35 analysis. It's clear that they approached it like the board is doing now, which is to say, well, look, because the public interest is an ingredient in the exemption, well, I mean, we'll extrapolate that to section 35 and say, hey, presto, that's the end of the matter. But that's with respect, that's just not the correct approach. Section 35 is an override provision that is precisely triggered by the finding of by the conclusion that the document is exempt.
Right,
but
the decision letter itself says these documents are not disclosable, notwithstanding section 35. I mean, it's the point that I put to you before. I mean, does that not expressly indicate that the decision maker has had section 35 in mind and has concluded that the documents are not disclosable, notwithstanding section 35, they having had this in mind?
But it's a bold assertion. It's a mere recitation of section 35. It's a mere reference to section 35. It is a mere assertion. That cannot, with respect, be what this act requires. When you speak about section 35, it cannot be right for a public authority to simply say in the decision letter, which requires a reasoned decision to be given to the applicant, to say, and not in having regard to simply say, as they've done, let me get the exact wording, and are not disclosable, notwithstanding section 35. The big question, the elephant in the room is, well, why? And are not disclosable, notwithstanding section 35. Why?
Well,
how are you
I'm hesitant to be drawn into answering your question, but it might be said on the other side that the answer to the why question is because the factors, the public interest factors tending against disclosure outweigh the public interest factors in favour of disclosure. That is why. Well,
my lord, if so, you say so, you will give some. You might say a paragraph of something about the fulcrum of the weighing up of it. But my lord, the short point is it will not be. It is inadequate and insufficient to simply recite the provision without more. Look, what they've done is to recite the exemption, because all of what precedes that line and are not disclosable notwithstanding section 35, everything that precedes that goes to the exemption. It goes to making out the exemption. So when you read it properly, my submission is that all that precedes that goes to tell you about the exemption that they invoked and that it is they consider the information to be exempt. I'm happy with that. I have no complaint and quarrel about that. What my complaint is that having done so, when you come to the section 35 balancing exercise, you say nothing except this one-liner that it is not disclosable, notwithstanding Section 35. And I say more is required because remember the purpose of this reasoned decision is to enable you to know whether you should exercise your right to seek judicial review. And how are you to exercise your right to seek judicial review if they tell you that the exemption is made out on this basis, and then go on to say, when with respect to the balanced excise, well, and are not disclosable notwithstanding Section 35, without telling you why. What would have been required there is some level of engagement with the factors that you took into account that favor disclosure, and to engage with it and at least say something about it. You could pay scant regard to it even, but you have to say something about it. But here there is nothing. And the attempt
so
to...
if, Mr. Ramlogan, if they'd said, in light of the public interest considerations against disclosure outlined above, the document's not disclosable, notwithstanding Section 35, would that be good enough?
No, I think they would have to. I think they would have to treat with the considerations at minimum, the considerations advanced by the applicant, to say, well, look, we didn't take them into consideration because we didn't find them to be relevant or legitimate reasons to favor the public interest disclosure. But you would have had to take those into account and say something, and that's precisely my point. By saying nothing and making the leap of logic to say, well, we must assume that they accepted them, found them to be relevant, took them into account, but jettisoned them under Section 35. I mean, all of that is really writing an affidavit that doesn't exist for a deponent that isn't present in court.
Mr. Ramlogan, the test can't...
And that's my complaint. What the public authority would have had to do is to say, in addition to the issues they considered in relation vis-a-vis the exemption, would be to say, well, hang on, we've also considered, now that having realized it's exempt, we did go on to take into account your considerations, 1, 2, 3, 4, or just say all of the considerations in your letter. However, we found that, the factors that militated against disclosure, as mentioned above, or furthermore, 1, 2, and 3, because there may be additional factors that they take into account when they're making that wider consideration. But you have to engage with it. You have to engage with it. To not engage with it, I mean, how would you, for example, as an applicant, know if you have a rationality challenge, a viable rationality challenge, when you don't know what the reasons for the balancing are? Balancing is not just a matter of scales. There need to be some evaluated judgment with some degree of reasoning.
Well,
so that,
Mr.
I mean,
Ramlogan,
that's
surely
why I
you know,
think...
if you had a rationality challenge, if you could see the list of public interest factors in favour of disclosure on one side of the balance sheet, and you...
Sorry, my lord, you're breaking up. Sorry, my lord.
What I was putting to you is this. Surely one would know if you had a rationality challenge for the purposes of bringing judicial review proceedings, if you could see the public interest factors in favour of disclosure on one side of the balance sheet, you can see the public interest factors against disclosure on the other side of the balance sheet, with the expressed conclusion under Section 35 of the public authority that there should not be disclosure. And one could then see, from looking at both sides of the balance sheet, that an irrational view had been formed by the public authority that the balance sheet items in favour of non-disclosure did in fact outweigh those in favour of disclosure. I don't see any difficulty about someone being able to determine whether they had a rationality challenge or not on that basis.
Well, I can see that, but also, may I posit this for your consideration respectfully? That wouldn't assist you with knowing what factors they took into account as relevant considerations and what factors they didn't. That would assist you with them.
But I mean, that comes back to the point that I've already put to you. Nothing in the decision letter indicates that any of the public interest factors in favour of disclosure put forward by your client are contested by the public authority. You keep saying they should indicate whether they're treating them as irrelevant. They don't. They've treated them all as relevant. And so if those are all on the side of the balance sheet in favour of disclosure, and they're being weighed against all the factors on the other side of the balance sheet against disclosure, I'm struggling to see why one cannot see from that and the conclusion expressed as to Section 35 what the mental process has been of the public authority sufficient to know whether one has a judicial review claim against the public authority or not.
Well, my Lord, at the risk of being repetitive, the short point is there is simply no evidence to say that they took into account the representations made. It's an assumption that the board is making respectfully that they did so, and giving them the benefit of the doubt instead of the lay applicant, that I think the act simply doesn't sanction, because the bias in the act is in favor of the citizen, the aggrieved citizen, who is applying for the information. The public authority is well resourced with an army of legal advisors, and they must surely express themselves clearly, explicitly, and in a way that people can understand, rather than to deduce by way of inflection, assumption, and inference. It's an inference, respectfully, that you're asking the applicant to draw, that because they've written this letter, but make no mention, absolutely no mention, of a single factor that favors disclosure in the public interest, that you must nevertheless make the assumption that they took them all into account, they found them all to be relevant, and not only did they take them into account, they took them into account, they balanced them with the countervailing competing considerations that militate against disclosure, and they somehow managed to, and they arrived at this conclusion. All of that is being supplanted without it being there in the evidence. It reminds me, my lord, of what was said in the case of Science Research Council and NACE, and it was a case of public interest immunity. And, the court said that the metaphor is one that is one well worn in the law, but I doubt if it's a metaphor, if it's more than a rough metaphor. Balancing can only take place between commensurables. This is a more complex process than merely using the scales. It is an exercise in judicial judgment.
Forgive me, Mr. Ramlogan. That's clearly right. There are lots of contexts in the law where balancing takes place between incommensurate factors, and then a judgment simply has to be made about their relative weight, even though they're incommensurate. That's true in the PII context just as much as I would suggest it's true in this FOIA context as well. Because in the PII context, you're balancing the public interest in open justice against a range of other public interests, for instance, in the disclosure of secret agents and so on, which are not commensurate factors, but which are balanced according to the PII jurisprudence to which you've referred, without any difficulty at all.
Well, my lord, I hear you. I see that in this context, I think a little more is required than just a tabular recitation. I think there must be some form of evaluative judgment. There must be an exercise of some degree of analysis. It doesn't have to be, as I say, like a judgment from a court of law, but something more than just a bare recitation of the section is required, bearing in mind that the purpose of that letter is a means to an end, which is to enable the citizen to know whether they should seek judicial review or not. And I don't see how, with the greatest of respect, that the citizen can make an informed and intelligent decision unless they're told by the public authority, we've accepted your representations, we've taken them all into account, we found them to be relevant, but here's the position, as it were. I mean, nowhere in the letter, nowhere did they even say that they've considered the duty to see whether a redacted version of the documents could be possible under Section 16, for example. There's nothing, even a mention of that. I mean, all of that one would expect a public authority to say in the this access decision letter. Look, we found it to be exempt. We did consider whether or not we can give you redacted copies. However, unfortunately, we can't just edit out and redact the gas price and give it to you, or we can't give you a redacted copy. I mean, there simply is none of that. It's too threadbare in my respectful submission. My Lord, may I, on that note, just briefly to take you to the actual provision of Section 35. It's at page 1087. And just to show you, it says, notwithstanding any law to the contrary, and I presume that will include the sections that preceded those words, meaning the exemptions. Notwithstanding any law to the contrary, a public authority shall give access to an exempt document. So the public authority, it's addressed specifically to the public authority, and it shall give access to an exempt document. Where there is reasonable evidence, we can skip those, and where in the circumstances giving access to the document is justified in the public interest, having regard both to any benefit and to any damage that may arise from doing so. That's the balancing exercise. They must consider, on the one hand, the benefit. Nowhere, absolutely nowhere, does the public authority tell us, well, what's the benefit that they've considered? Nowhere. What is their assessment of the benefit that could arise from disclosure? We don't know, do we? They don't tell us. And we know what the damage. It's a biased decision because we have a 114-page affidavit that comes to tell us what the damage is. But we have nothing about, well, hey, this is what we have to say to you about the benefit of disclosure in the public interest. There's nothing on that. And that's why we say it is fundamentally flawed and it is not a proper Section 35 analysis on that note, my Lord. My Lord, they would have had to consider the benefit and damage. They didn't. May I just move on quickly? May I show you, my Lord, what the way the courts have dealt with this matter in the before? And bear in mind the use of the words essential public interest in Section 3.2. Can I take you to page 1164? This is the judgment from the Court of Appeal of Caribbean Information Access, and I'll take you to page. I'll take you to paragraph 3. In my opinion, the trial judge failed to properly consider the intention and purpose of Section 35 and the practical implications for the respondent in the context of the scheme of the legislation. The practical implications. In my opinion, the respondent had a duty to consider the mandate in Section 35 and to consider whether the documents requested, though exempt, should still have been disclosed, and to have explained this in its written case, in its written response to the request. So it has to give an explanation, to have explained this in its written response. There is no explanation, but just simply a bare assertion. And that's how the courts have interpreted it in Trinidad. I take you next to page 1425.
I'm sorry, I missed that reference, Mr. Ramlogan.
Page 1425, my lord. I apologize. Page 1425. This is the Joint Consultative Council case. And in this judgment, the court says, paragraph 20.
Sorry, I must. Forgive me, Mr. Ramlogan, I must have the wrong reference. Did you say?
Oh, sorry, beg your pardon, my lord. It's
1475?
1425.
1425.
Thank you. Paragraph?
Paragraph 20. Once exemption is claimed by a public authority, the Section 35 public interest override assessment and analysis must be undertaken by a public authority. Thus, following any claim in this case to exemption from disclosure pursuant to Section 29 of the Act, the appellant was obliged to carry out the Section 35 evaluation in the context of the exemption claimed before deciding to deny access to the information sought. Furthermore, the gravamen of this evaluation also had to be disclosed in the appellant's reasons in writing for denying access to the information sought by the respondent, the gravamen. The justification for this public interest evaluation and override, even where documents are considered exempt, has both specific and general statutory underpinnings as well as a constitutional warrant. And can I take you to page 1475, paragraph 73.
Which authority is this?
This is it's the same JCC case, but I believe this is the judgment of Justice Barrow. Justice P. Barrow. The Section 35 override must be considered by the public authority on each occasion on which it determines that a document to which access is sought is exempt. Having found the document to be exempt, the public authority must then decide whether
Mr. Ramlogan,
either...
I'm so sorry to interrupt you. It's my fault again. I missed the page reference.
Oh, so that's all right, my lord. It's page 1475.
70.
1475.
Okay.
And it's paragraph 73.
And that's the same authority, is it?
Yes, it is, but it's a different judge. It's Justice of Appeal Barrow. Now, my lord, look, my lord, there is a plethora of authorities that's from the Court of Appeal that speaks with one voice to this analysis. And you know, I don't propose to take you through all of them. We've set them out in the written case, but I just wanted to show you that the way we have interpreted and administered this Section 35 is that it calls for a little more. So you have to give the gravamen and substance of your reasoning in relation to Section 35 to the applicant. And that is born out of our own experience with how public authorities respond and treat with FOIA applications. And if you give them an inch, they're going to take a yard, and it's going to frustrate practically the objective of this act. Bearing in mind, as I say, you know, it should be limited by essential public interest and all of that. Now, can I just also take you now? It's either they did the Section 35 analysis or they didn't. If they didn't, and we are right on that, then we say the decision is fundamentally flawed and ought to be quashed. It's similar to, for example, where there's a duty to consult before you arrive at a decision, and if you didn't comply with the duty to consult imposed by the statute, then the decision is flawed and should be quashed and remitted. Can I take you to page 1427? This is in the JCC case to show you how it is analyzed. At 1427, Justice Jamada, paragraph 26, who now sits in the Caribbean Court of Justice, he says,
I'm sorry, for my part, I also now apologize. Could you just tell me the page number again, please?
It's 1427, my lord, 1427. Paragraph 26.
Paragraph?
26.
26 and 27.
26, thank you.
Yeah.
Thank you very much.
Yeah. And it says, these 5 principles, the general aim, the general right to information, the general presumption in favor of disclosure, the duty to facilitate access to information, the obligation to explain in writing why the decision to deny access has been taken and to do so promptly, and the obligation to inform an applicant of his or her right to redress that are available are all part of the context in which the evaluative and balancing exercise mandated by Section 35 is to be carried out. Thus, one would reasonably expect that if a public authority has decided that a document is exempt and that it should not disclose the document even after having carried out the Section 35 public interest override evaluation, that in its written reasons, it would detail the following: the reasons for claiming the exemption, and the cases where Section 35A to be applied, that there is no reasonable evidence of the 4 stated factors, and most importantly, why denying access is necessary for the protection of essential public interest, including factors it considered in relation to both benefit and damage that may arise from granting access to the information sought. So it is a little more, we have taken it as a little more, with a little more a degree of a little more substantial than what has occurred here, and that is why, my lords, we say that the balancing exercise from the evidence has fallen short in this matter. Can I take you next, my lord, to page 1? Can I take you next to page to the judgment of Justice of Appeal, Bodu Singh, whose dissent we identify within this matter, and I will find that. Show a page.
So it's the dissenting judgment in this case in the Court of Appeal. Is that
Yes.
what you're looking for? Right, thank you.
It starts at 882, my lord.
882.
Yes. And
Am I right in thinking that there were two judgments in the Joint Consultative Council case, both delivered on the same day?
I think there were 3 judgments, my lord. There was a dissent
Delivered
from
on the
Justice
same day.
Narayan.
Yes. No, because you've
So there
got
was-
this page 1425 and 1427, and also 1475. The first two were in one judgment. 1475 was in another judgment.
Yes, I
With-
think that's right, my lord.
Yes. Okay.
So, my lord, if I take you to page 885, paragraph 133, the learned judge says, it should also be pointed out that when an applicant seeks information, the only way an applicant can know if Section 35 was considered regarding any exemption claim is if he was told that Section 35 was considered and what were the factors that were considered. If the only response, in effect, is that Section 35 was considered, there'd be no way of knowing if only lip service was paid to Section 35. Saying that something has been considered is not the same thing as evidence, which proves that it has been considered. In other words, if it was sufficient just to state the phrase Section 35 was considered without more, this could be utilized as a means of avoid conducting this exercise. There ought to be some demonstration that both the factors against disclosure and those in favor of disclosure were considered. If there is no such demonstration, an applicant would not know what, if any, considerations were in fact taken into account. Furthermore, the applicant would be placed in a difficult position to evaluate if a judicial review challenge should be made. No informed decision on a challenge could be made. At paragraph 135, he said, the judge says, it would send more cases, the last sentence, it would send more cases to the court than should be sent because the applicant would have to come to court to learn, well, what was the Section 35 analysis that took place? And that's what happened here. You only truly know what they claim took place in a 114-page affidavit after you've come to court, when you have the opportunity for the ex post facto rationalization that occurred in this matter. And we said that that's just not how the Act is meant to operate. The judge, if I take you next to page 892, paragraph 151. Again, whilst there may be overlap in some of these factors under Section 35, that is the exemption factors, there was no demonstrated analysis of the considerations under Section 35A to D, nor that of the documents being subject to disclosure as being justified in the public interest. 152, on none of the requests did the decision letter address Section 35, save for the blanket nod to or acknowledgement of section.
Just as a small point of detail, paragraph 151, should the reference to Section 35A to D in the second line, should that be to Section 31?
No, I think he's making a general proper statement that the public authority has to consider Section 35 and the public authority must consider the duties objectively imposed by the statute on the public authority to consider section, the whole of section 35.
Yes, I'm so sorry. So the judge there is talking about the first part of section 35.
Yes. So that's what I'm saying. Even if the applicant directs your attention only to the second limb, that doesn't absolve you of your duty to consider section 35 as a whole.
I see.
In the context of the thing. And there is no evidence that they consider sections A to D to say whether there's any unauthorized use of public funds or anything of the sort. I mean, you have to bear in mind, if you read the newspaper articles, the problem in this case that gave rise to concern, public concern, is that everything was being shrouded in mystery and obscurity, and the government was simply saying, we are doing something, you must accept, listen, trust us, it's going to be great and good for the country, but we can't tell you anything about it. It's your money we're going to spend, it's your money we're going to commit, but we can't tell you anything about it. I mean, it's an affront to the rule of law, and the cardinal principles upon which a constitutional democracy is based, with transparency, public accountability, and good governance at the forefront of it.
Yes, I see.
No one knows how much money you're spending on the pipeline, what's the cost. The public was concerned and outraged because they simply they were not being provided with any substantial information relative to something that you could be mortgaging our children's future and the treasury to Venezuela, and we don't know. Paragraph 152. On none of the requests, 1482, therefore, the decision letter addressed section 35, save for the blanket nod. On that basis alone, there is justification for remittal of these matters to be reconsidered by NGC, there being no demonstrated compliance with section 35. And then I take you finally to I'll analyze the affidavit evidence, and we then come to paragraph 170 on page 897. And the judge says, an applicant will not always seek legal, may not always or even usually seek legal advice before making a request. The Act doesn't require him to identify public interest factors, although this may be helpful. There's no place on the prescribed statutory form for you to identify any public interest factors or engage with section 35 as an applicant. The prescribed form has no space for that. The primary right in the FOIA is to be provided with information once the person is entitled to it, not having to make an airtight case for it. The public authority has a duty to consider each request on its merits and apply the relevant provisions. Without seeking to be exhaustive, other considerations...
Mr. Ramlogan, before you... I was interested in paragraph 171. At an earlier stage, you had replied to Lord Sales that there were no further public interests in favour of disclosure being put forward by the applicant. But here we got a list. Was this list a list devised by the applicant or devised by the judge in paragraph?
I think it's a list devised by the judge to illustrate the point I'm making, that the public authority is the one that is responsible for conducting the section 35 analysis, and they're not handcuffed to the representations made or not made by the applicant, but rather it's meant to consider section 35 independently and consider all of the relevant considerations that might fall within their contemplation as a responsible public authority. And the short point here is that we have not had...
Isn't Roman numeral 2 just transparency and accountability?
But my lord, no, we say that this list illustrates that whilst that might be a generic, something generic, you would at least have to get into some specifics as to what, especially in a case like this, on the factual matrix of this case, where you know, because you live in Trinidad and you're reading the newspapers, you're listening to the radio talk shows, you're hearing what the public concern is. You know what the issues are, so that it's not to be decided in a vacuum. This was a hot topic. When you read the articles and which we've put in evidence, you will see that the public consternation and disquiet was real alive and kicking because there was just simply no information flowing to the public about what was going to be a massive, major project with environmental, political, diplomatic, and financial long-term implications. And, you know, it struck at the heart of a constitutional democracy that is based on the rule of law with transparency and public accountability. I mean, we've got to take it in that context. And that's why the judge comes up with this list to say, well, look, I mean, it's not for me, but they are obvious, but this is based on what is in the socio-political environment in Trinidad, in the public domain. And it's easy to cull a list, as it were, from it. And we say that
it seems to be the consequence of your submission that if an applicant makes an FOI request without giving reasons, then Section 35 requires the public authority to think up every reason, as, for example, the judge does in paragraph 171, and presumably expose themselves to challenges that there was another public interest which they hadn't thought about. A JR challenge based on failure to take account of a relevant consideration. I mean, just how onerous is this obligation to be?
No, it's not. That's putting it on the far end of the spectrum. What I say is, regardless of whether an applicant puts forward public interest factors that favor disclosure or not, the statute imposes an independent statutory duty on the public authority to exercise the override, and in so doing, it has to inform the applicant as to what were the relevant considerations it considered. Now, public authorities are not, they're well resourced and they have their staff and their legal department and so on. But the point is, no one, unless they missed something that was really obvious, you wouldn't really think that a judicial review could succeed. But the point is, they've got, as a matter of rational thinking and a responsible public authority, they will be able to say, well, look, these are the relevant considerations that we've considered that favor disclosure in the public interest. And these are the ones that we say militate against disclosure. And this is how we've analyzed it, and this is our conclusion. That's all. It's not a very onerous task, my lord. Almost every decision a public authority has to make, whether it's in the field of immigration, planning, or housing, you have to give, where there's a statutory duty to give reasons. It must have some substantive content to that legal duty imposed by Parliament on the public authority.
Mr. Rand,
in the context,
if it were put to you that the factors in paragraph 171 amount to a rehearsal in different language of the points made by the applicant himself in his request letter, what would you say to that? So, for instance,
I would
at little 5, citizens may be concerned about arrangements being entered into with a state subject to international sanctions, which there appears to be political, social, human rights and economic concerns. I thought that was a point that was taken in the letter. Little 8.
Oh, no, I can save you some time by conceding.
Mr. Amlogan, please allow Lord Sales to finish his question.
Beg your pardon.
I'm just sort of picking illustrative examples that appear to traverse the same ground as the applicant himself had traversed in his letter, using different language to make the substantive points. And I just wondered if you had a reaction if that were put to you.
Yeah, well, I readily accept that there's some overlap, but I think there might be some new ones. But the short point is that it would be for the public. It is for the public authority to formulate the relevant and irrelevant considerations on the issue of factors that favor disclosure and factors that militate against disclosure. And that's simply the point. They're not bound by what the applicant says in terms of his own representations. It's not meant to be an exhaustive list that the public authority is handcuffed to. But the point, and the short point is, it's for the public authority to simply conduct the balancing exercise, and that's all. My lords, I know that I'm now my speaking time has expired, and I don't want to eat into the reply time. But my lord, I do say in closing that the consequence of the failure to give any adequate reasons as contemplated by the Act, given the bias in favor of disclosure, given the object of the Act and so forth, I think that the decision is invalid. It ought to be quashed and remitted. I think we are ad idem on that, in that the respondent accepts that if you find that it didn't comply with the duty to give reasons, or that the balancing exercise was not properly performed or not performed, that the decision should be quashed and remitted. You'll find that in their written case at paragraph 29.3 at page 1037. But we do say that the reasons obligation is an independent and enforceable legal obligation, and that it vitiates the decision if it is not one that is there. We also make the point, my lord, that in the affidavit filed by NGC's Respondent, there are reasons that are given in that affidavit that militate against disclosure that do not feature in the access decision letter. There are, for example, the acute shortage of natural gas. Shell had substantial investments in Trinidad and was a key participant in the energy sector, and it was critical for it to remain committed to Trinidad. The whole impact it would have on Shell. A lot of, in 114 pages, if you match that against what's contained in the columnar form decision letter, then you will realize that a lot of new stuff was now given ex post facto that is not really permissible, or not to have been permitted in accordance with the Ermakov case, which cautions against allowing for new reasons to come in under the heading of elucidation and mere particulars, my lord. So, my lord, with that, my lord, I think I would leave the remaining time for my learned junior, who is going to do the reply. But in concluding, we say that the decision ought to be quashed and remitted. I thank you. Unless any further questions.
Thank you, Mr. Ramler.
I'm deeply obliged.
We are almost into the break time, so the board will rise now and resume again at 3:20.